I want to kind of, ooh.
Oh. Hello, everyone. Coast to Coast Legal Aid of South Florida would like to formally welcome Teresa Griffin from the Department of Revenue of Florida to discuss with us today the Child Support Legal Clinic. Teresa, give us a little bit of a background and introduction on yourself so we can get this, party started.
Okay, so good morning. As Bertha said, my name is Teresa Griffin. I have been with the Department of Revenue since 1992, so a little bit over 30 years. And I've actually been with the state of Florida, working for the state of Florida in various positions for a total of about 35 years. So I have just a little bit of experience with as far as the child support program is concerned. So yes, that's me.
She's being a little modest, but I think she has a lot of experience. So and will help us graciously as we go through these PowerPoints together.
Okay, so what we're going to do is we're just going to go over just a few of the PowerPoint presentation slides, and then, if we have any questions, we can go ahead. So now the vision for the child support program, the next slide. The vision is the child support program. What we do is we like to work with families so that we can ensure that the child or children in a household receive the child support that they need and they deserve. Now, on the next slide, let's talk a little bit about the mission for the child support program.
Let's absolutely do that. Here you go.
Our mission, as far as the child support program is concerned, is we seek to serve our customers. We want to make sure that all of our customers are treated with the utmost respect and professionalism. We also try to do as much as we can to make it easier for the parents to receive or obtain the child support for their child or children, as well as for the parents to provide the child support for their child or children. And another thing that we like to do is we like to work closely, not with just the parents, but also with the partners and the communities so that we can seek to always improve on the child support program. So now the next slide, we're going to talk a little bit about the services that we provide. When it comes to the child support services, typically individuals can receive child support services just by applying through the program. They can, if they decide not to seek the services through the child support program, they can also obtain child support by utilizing a private attorney or filing their own pro se actions. Now, with the child support program under the Florida Department of Revenue, we work with several different partners, and those partners help us to fulfill our mission, which is, again, to obtain the support for the child or children. Some of the partners that we work closely with, we work with the federal government, we work with the Florida courts, we work with Florida law enforcement, some financial institutions, as well as employers and other state agencies. So now when we talk, go ahead, I'm sorry.
No, I have a quick question now that you're talking about, the many ways somebody can apply for child support. Can you briefly just tell us the difference? What would be the difference of a person coming over to your office wanting to get child support versus them going pro se and filing maybe in court?
Honestly, because I don't have a lot of information as far as the requirements for taking an action pro se, the one thing that I can say is by coming through our office, there's no fee. They don't have to pay anything. They don't pay the filing fees. They don't pay any court costs, anything like that. So when individuals apply for services through the child support program, they're not required to pay any type of cost or fees. So I'm not sure if there are fees required when they take action pro se. And then also by coming through our office, we do everything for them. So once they seek our services, we're going to be the ones that will file the action with the courts and, take the appropriate steps to either establish or enforce a child support order.
How long does the process take for your office administratively to get the child support done?
So there are a lot of things that factor into that. If it was like, typically the term I use is the perfect scenario. So in a perfect scenario, when we take the appropriate steps to establish an order administratively, we know exactly where that individual is. We can get that individual served right away. That individual files a timely response. We get all of the necessary documentation. And then if in a perfect scenario, typically with an administrative action, we can usually get an order within about 3 to 6 months. 6 months is the kind of like the the extreme, but it is going to vary, because when we start talking about the steps that we take to establish an order administratively, there are a lot of things that factor into it.
Great, great. Thank you. Thank you for that information. Everybody can always on this Facebook Live, please provide comments and any other questions that you have, but we'll take a lot of those questions and comments at the end as well.
All right, so let's talk a little bit more about some of the services that we provide. Now, when it comes to obtaining child support services, typically what an individual can do is we will provide a website at the end of the presentation where they can actually go online and submit an application online. Now, if we have a household that has applied for or they're receiving public assistance, those cases actually come to us automatically. So if an individual applies for any type of public assistance benefits here in the state of Florida, that information interfaces with our system here at the Child Support Program, and the cases are open automatically. And one of the things I touched on earlier when we were talking about the difference between pro se and coming through us is that, of course, there's no cost for any of our services. So ultimately, you're going to get an attorney, you're going to get quote unquote private investigator, and you're going to get someone that will handle all aspects of your case, and there's no charge to you. Now, just a little bit of statistical information as far as the child support program, and then we'll talk a little bit more about the services that we provide. Now, here in the state of Florida, we provide services. We have over 1.3 million cases throughout the state of Florida. Those cases involve 1.1 million children. And then 82% of the families that actually have cases on our system are cases that we already have an established order. So there is already an existing support order. Okay, so now a little bit more about the services. When an individual contracts through the Department of Revenue, what we're going to do is we're going to provide them with the resources so that we can locate the parents. We can locate any employment information as well as any asset information. We'll take the appropriate steps if paternity is an issue to establish paternity. If it's a situation where there is not an existing child support order, we will take the appropriate steps to establish an order. And then once the Department of Revenue is involved, if an individual would like to have their case reviewed to see if a modification in the child support obligation is warranted, we will also provide those services as well. Another key thing with us here at the Department of Revenue is once an order has been established, we're the ones that will actually receive the child support payments, will distribute the child support payments. And the way that our system is designed to monitor the receipt of those payments. So if there's a situation where a parent is not complying with the financial terms of the order, then we will automatically take the appropriate steps to enforce the order. It's not a matter of a parent having to go out and try to, get their child support on their own. Our system is designed to take the appropriate steps to enforce the child support obligation. Okay. So now let's talk about establishing an order. Now, when it comes to the establishment of a child support order, we can do that through a couple of different ways. We can do it either utilizing the administrative process or the judicial process where the court's involved. Regardless of the steps that we're going to take to establish an order, be it administrative or judicial, there is a standardized formula that we're going to use to determine the child support obligation. When we establish an order, if paternity is an issue, our orders will address paternity. It may require the parent who has the obligation to pay the support to provide health insurance or to cover a percentage of the medical expenses. And we touched on earlier about modifications, so that once the child support obligation has been established, if there is at some point in the future a change of circumstances, then we can take the appropriate steps to modify that order to either increase or decrease the child support obligation amount. And with an administrative order, administrative child support orders that are established, I can't talk, utilizing the administrative process. Basically, in that case, everything is done by the Department of Revenue. Even though the order is established using the administrative process, it carries the same weight as a judicial order. So a lot of times individuals have a tendency to think, oh, if we go to court, it's going to be better. The way the Florida statutes actually has given us the ability to establish orders utilizing the administrative process. So once we establish that administrative order, it carries the same weight as a judicial order. Now, a couple of things as far as how that administrative process works. Once we have made the determination that we're going to be utilizing the administrative process to establish an order, we're going to send documentations to each party. The parties will return the documentation. Once we get that documentation back, we're going to then utilize the system to determine the child support obligation. And we use the term guidelines because support guidelines is the method that we use to establish the child support obligation. And just a little bit about the guidelines. The one thing that I like to make sure that everybody understands when it comes to the child support obligation and guidelines is that the formula that we use with the Department of Revenue is the exact same formula that an individual would use if they had a private attorney, because that formula is incorporated or included in the Florida statutes. So, I don't want individuals to think, oh, well, if I had an attorney, I could get more child support. We use the exact same formula because that formula is included in the Florida statute. So the method that we use or the process that we use to calculate guidelines is going to be the same process that the attorneys use. And that applies when we're establishing an order using the administrative process. We're going to utilize the same formula. Now, with the administrative process, what we're going to do is once we determine the child support obligation amount, we're going to send the parties what we call a proposed order. And it's just that this is what we're proposing. We're proposing that the child support obligation is going to be this. This person is going to be ordered to provide the health insurance. This is how much retro or back child support is going to be ordered. And when we send that proposed order to both parties, they have an opportunity to state, oh, well, I don't think the retro should be of this amount because of X, Y, and Z. So that proposed order gives the individuals the opportunity to look at that information. And if they feel that some part of that order needs to be changed, they can provide us with the necessary information and we'll review it and we'll determine whether or not we need to do an amended proposed order. Another thing that the parent who owes the support, who's paying the support, has the ability to do through the administrative process is to request an administrative hearing. So once we start that administrative process, if the parent who owes the support decides that they want to have an administrative hearing, that is something that they have the right to request. And, the case will go to the administrative law judge and they will make the final decision. And ultimately, at the end, the final outcome is going to be a final support order. And that final support order is going to carry the same weight. We're going to include language for an income deduction. That order is filed with the courts. The clerk of the courts is the official record keeper. So all of the child support payments will be reflected at the clerk of the courts. So when it comes to the payment of the child support, they're going to follow the same process that they would for a judicial order. So now that's a good segue into the next slide, which is the judicial process. Now with the judicial process, what we have in that particular situation is we are going to be taking the appropriate steps to establish an order using the courts. We have what we call legal services providers, and those are attorneys that work with the Department of Revenue, and they're the ones that take all of the action as far as any type of judicial as far as any judicial action is concerned. So we send them the necessary information. They file the action with the court. The parent is served by the sheriff or a private process server. After that parent is served, that case is set for a hearing. At the hearing, the attorneys are going to gather all of the necessary information, and then the attorneys will do the guideline calculation. So they will determine the child support obligation for the parent who owes the support. At the end of the hearing, order is going to be rendered. The order is going to contain some of the same language. It's going to have language for an income deduction. It's going to have language for health insurance, and it's also going to include instructions for the parent as to where they're supposed to send their child support payments. Now, when it comes to paternity, anytime we have a situation where the child was born out of wedlock, then we are required by law to establish paternity. Typically, when we take the appropriate steps to establish paternity, what we're trying to do is to identify who that child's legal father is. Here in the state of Florida, if a child is born out of wedlock, the father has the ability to sign that child's birth certificate. And once that father signs that child's birth certificate, that is what we consider to be the voluntary establishment of paternity. Now, if we encounter a situation where there is no father on that child's birth certificate, then that's when we're going to take the appropriate steps, either utilizing the administrative or the judicial process to establish paternity. And for us here in the Department of Revenue, we're going to utilize genetic testing to make that determination. And then the last step, the last step with paternity is once paternity is established, we will send the necessary information to the Bureau of Vital Statistics to have the father added to that child's birth certificate. Was there a question?
Yeah, there is a question, Teresa. Just a quick question. When you say establish paternity using the Department of Revenue administratively, what does that entail? Does the father now have legal rights over that child and now can just go about making decisions for the child and have time sharing, or it's just to establish an order for child support only? It doesn't really give him any legal rights to this child besides paying the support he needs.
So as far as the legal rights, I can't speak to that because I'm not an attorney. So I don't know what, once paternity is established, what rights, if any, it gives to that legal father. All we're trying to do is, because in order for us to move forward to address the issue of child support, we have to determine who that child's legal father is. So the main reason for us here at the Department of Revenue establishing paternity is so that we can determine what individual has a financial responsibility to support that child. So we're establishing paternity so that once we figure out who the legal father is, then we could go ahead and address the issue of support. Okay. Now, if they already have, like, if we have a situation, well, no, that's it.
Okay.
Does that answer your question?
Yes, it does actually. Okay. It answers my question on that. Thank you.
Okay. So now the next thing we're going to talk about is modification. Once there has been a child support obligation established, sometimes there are circumstances that may warrant a change in the obligation amount. Now, another thing that we can do here at the Department of Revenue is if we are actively enforcing an order and either parent wants their case reviewed to determine whether or not that child support obligation needs to be changed, they can request a review. And then what we're going to do is we're going to get all of the necessary information. We're going to evaluate that information. We're going to make a determination as to whether or not the change was voluntary or involuntary. And then based on that, we will, if we determine that it's an involuntary thing and it's permanent, then we are going to utilize the Florida guidelines, the same thing that we would use when we're establishing an order. And we're going to use those guidelines to determine whether or not it warrants either an increase or a decrease in that child support obligation. And if it is determined that it does warrant either an increase or a decrease, then we're going to move forward to modify that order. If that order was established using the administrative process, the modification is going to be done using the administrative process. If the order was established utilizing the judicial process, then the modification is going to be done utilizing the judicial process.
Teresa, I do have a question on the modifications. Mm-hmm. Let's say a person goes to your office and wants to do the process administratively, and but then they want to go then through the legal route of maybe using the court for the rest of it, maybe time sharing and other stuff. They want to go through more kind of paternity or dissolution of marriage through that route. Now we kind of have two orders because we have an order in the past and now one here where the courts are now trying to figure out child support. What do you kind of advise there? Does DOR get involved in those cases too? Does the Department of Revenue get involved in a judicial case?
So here's the thing. Let me just speak first to, let's use the first scenario where the Department of Revenue utilized the administrative process to establish an order. And when it comes to whether an order is going to be established using the administrative process or the judicial process, that is not something that an individual can decide. Our system is going to decide whether or not we're going to utilize the administrative or the judicial process. So let's just say hypothetically, we established an order using the administrative process. So now we have an administrative order for child support. And now the parties go in and they get a divorce, and there is child support addressed in that divorce. Then that case, that divorce is going to supersede that administrative order. So in that case, the ongoing support obligation for the administrative order is no longer something we can enforce because we have a superseding judicial order. The only thing that may be enforceable under that administrative order is whether or not any past due support or arrears are owed. So in that scenario, it's going to either be one or the other. Either once we establish an order administratively, there could subsequently be a superseding judicial order. Or if we establish an order using the judicial process, at that point, any action as far as modification or whatever is going to also be done using the judicial process.
Okay, so it just depends on what is administratively and then what is kind of judicial. And judicial orders are superseded. Are more like superseding than administrative orders. Is that
if it addresses the child support? There have been some situations where we had an administrative order for support, and then when the parties got divorced, the language in the divorce deferred to the administrative order. So in that case, there was no superseding order, so we continued to enforce the administrative order for support. All right. So now that we've talked about the process that we use to establish and modify, let's take a look at some of the actions that we use to enforce an order. So when it comes to the enforcement of a child support obligation, the Department of Revenue, the great thing about here in the state of Florida, the Florida statutes provide us with a lot of enforcement remedies. So if we have a situation where a case meets the criteria, then we're going to use a variety of different remedies to try to enforce the case. Here in the Department of Revenue, we work with a lot of different external partners. It talks about employers, financial institutions, IRS, other state agencies, and all of those partners, they provide us with the assistance for us to enforce the child support obligation. Now, we're going to talk in detail about some of these services, but we're going to talk a little bit about the payment agreement. We'll talk about wage withholding, some of the suspension actions that we can utilize, some of the court actions, the liens, some of our other collection methods, bank accounts, credit reporting, medical support, and costs. So first, let's take a look at the payment agreement. Now, the payment agreement, this is something that the Department of Revenue created a few years ago. And what we did was we realized that when or if we had an individual who fell behind in their past due support obligation, a lot of times it was through no fault of their own. Maybe they were unemployed for a few months and they were not financially able to pay those missed child support payments. And now that they're working, they still owe a few $1,000s in past due support, but they can't afford to pay it in a lump sum. So that payment agreement is something that the Department of Revenue can enter into with that parent who owes the support. And what it does is gives them the ability to kind of make payments toward their past due support. Now, it's not absolving them of their current support obligation. So they still have a responsibility to pay that. But what we're doing is we're saying, okay, we know you fell behind, you owe $5,000 or $6,000 in past due support. You can't afford to pay $5,000 or $6,000 in a lump sum. So maybe you can afford to pay an additional $50 a month. So in addition to your regular child support obligation of $500, you'll pay an additional $50 until that $5,000 is paid. So that payment agreement basically is something that the Department of Revenue created to kind of assist the parent who owes the support so they can, pay off their past due balance. Now, wage withholding, this is probably the most popular way that we utilize to collect child support. Our system, the system that we utilize, it interfaces with the Federal Department of New Hires. So what happens is when an individual is hired, that information is going to be populated in our system. If our system sees that that individual has an obligation to pay support and there is language in that order for income withholding, then our system will automatically send that income deduction notice to the employer. There have been situations where a person has been hired and probably when they get their first paycheck, child support is already coming out. So the great thing about wage withholding is the way that our system is designed. It does interface with a lot of different resources. So once we see or it sees that someone is working, it will automatically send out that income withholding. And you'll see it states that more than half of all of our child support collections come from wage withholding.
Now, Teresa, I do have some questions as to like the payment agreement. When you're saying an agreement, who's the agreement with? Is it with the payor, with the person who has to be paid? Are they going to talk to that administrative attorney in the department to discuss, let's negotiate some terms, or is it between the parents?
So what the payment agreement is between the Department of Revenue and the parent who owes the support. Now, the payment agreement, it's not like a court order. It does not change the terms of the order. It's just an agreement between the Department of Revenue and the parent who owes the support. Because ultimately what we're trying to do is when we have a parent who's fallen behind in their support and they want to pay, they want to, get caught up, then that payment agreement is something that the department designed to kind of help them with that. So it doesn't change the terms of their support obligation. It's not something that's ratified by the courts. It's just our way, the department's way of telling the parent, hey, we know that you can't afford to pay thousands of dollars lump sum. So if you're willing to enter into this agreement to pay an additional, then that will help you get this past due balance paid off a lot faster.
All right. And what about wage withholding? Let's say there's a parent that comes to your office. He's not working at the moment, but you guys have a child support order anyway in place. Now he just got hired somewhere else. What resources do you guys use to does the parent, that payor, have to come to your office and be like, hey, I'm working somewhere else? Or do you guys just automatically get informed of that information?
So typically, depending on I think there is a requirement that if an employer employs more than, I want to say 25 individuals, their information goes through the Federal Department of New Hires. I may not have the correct term, but it's like the Department of New Hires. So that information is automatically reported. And once that information is reported, it will interface with our system. Now, if we have a situation where maybe they're working at like some, little family run business, it's only a few employees, in those scenarios, it's usually going to be the parent who has the responsibility to pay the support that'll provide us with the employment information. And then sometimes it will be the parent who is receiving the support that will provide us with that information. But yeah, it really is going to all depend on where they're working. And then of course, if we have someone who's self-employed or working off the books, then in that scenario, wage withholding may not be an effective enforcement tool to use in that scenario, in that particular case.
All right. Let's move on to
now, the next, it talks about suspension actions. Another thing that the Florida Department of Revenue has the ability to do, and again, a lot of these enforcement remedies that I'm talking about are things that we have the ability to do pursuant to the Florida statutes or federal regulations. Suspending an individual's driver's license, suspending an individual's passport. Those are just some professional licenses, hunting or fishing licenses. Those are just some of the licenses that we have the ability to suspend. Now, it's just like with wage withholding. In order for us to be able to suspend a license, we have to know that the license exists. Now, with driver's license, great. What is it called? The Florida the Department of Motor Vehicles. Thank you. So with the Department of Motor Vehicles, that information, because it's a state agency, it interfaces with our system. So if a person has an active Florida driver's license, that information is going to come into our system. And if at some point the case meets the criteria for driver's license suspension, their driver's license will be suspended, or the system will create the appropriate activity to suspend their license. Now, when it comes to some of those other licenses, like a professional license or hunting and fishing license, typically that's going to be information we would have to go out and look for. And once we find it and we load it in the system, then the system has the ability to create the activity to initiate one of those license suspensions. And usually what happens is, especially with driver's license suspension, we encounter situations where a person doesn't know their license is suspended until they either go to renew their registration or they get pulled over, because most people don't notify the Department of Motor Vehicles of their new address. So when we suspend their license, we're going to send that notice to the address that they have on their driver's license, if that's the only address. So driver's license suspension is one of the most effective enforcement remedies that we have. And that's going to be typically the remedy that once that person finds out that their license has been suspended or is going to be suspended, that's usually when they will contact us to try to figure out, what can I do to keep my license from being suspended? And that's when the payment arrangement is going to come into play, because if they can't afford to pay their past due, then what we're going to do is try to negotiate that payment agreement to say, okay, this is what we'll do. If you don't want your license suspended, this is what you're going to have to do. Okay. And then court actions, taking a case to court for the enforcement of the child support obligation is something that we can do. It's not something that it's not the first enforcement remedy that we look for. Usually when we say we're going to refer a case to court for contempt, it's probably because all of the other enforcement remedies, all of the license suspensions, none of those were effective. So we're going to utilize courts as a last resort. Okay. Now, liens. The Department of Revenue, we have the ability to place liens if a person has a car, if they have a boat, if they own any type of real estate, if they, trying to think what else, car, boat, real estate, that's it, homes, mobile homes, all of those things we have the ability to place a lien on. Now, let me just clarify one thing with the lien. The department's intent is not to seize the property. We place a lien on it to make it inconvenient or impossible for them to try to sell the property. So if we place a lien, let's say a person goes and they purchase a car, pay cash. So now when we place a lien on that title, that person is not going to be able to sell that car or trade that car in until that lien is released by the Department of Revenue. So our intent is not to seize it. What our liens will do is prevents that individual from trying to sell it until they satisfy the lien, which would be paying whatever past due support that they have. And believe it or not, especially when it comes to vehicles, or like you have individuals that may collect like classic cars and things like that, if they're registered, those are the liens that usually are the most effective, because they don't want to run, they don't want to take a chance on, if I have somebody who's willing to pay a lot of money for this car, now I can't sell it because the child support office has a lien on it. And then some of the other collection methods that we can use. If a person is entitled to any type of workers' comp or insurance settlements, in some situations, we may be able to levy or place a lien on those proceeds. A tax refund offset is another enforcement remedy that we can utilize. If a person is due a tax refund, we can certify that case, and instead of the refund going to them, it comes to us. Unclaimed property is another collection method. Lottery winnings. Now, this is the one thing most people are surprised at. But if an individual wins the lottery and they win more than $600, they have to go to the lottery office to claim those winnings. Well, when they go to the lottery office, they're going to fill out a claim form, and they're going to put their social security number on that form. So now once the lottery worker puts that social security number in the system, if they see that person, if it's a match with child support, they're not going to be able to get any of those winnings. What's going to happen is the Department of Revenue, we can intercept those winnings, and we can keep up to whatever they owe. So if a person wins $50,000 after taxes and they owe $60,000 in past due child support, yeah, we're going to keep all 58,000 of those dollars. So a lottery winning, that's another enforcement remedy that we have that most people are not aware of. And then the last two, it talks about reemployment assistance, also known as unemployment compensation benefits. So if an individual is eligible for or starts to receive unemployment, we can take a portion of those benefits. And then the last was the workers' comp. If an individual has some type of workers' comp settlement, then what we're going to do is we're going to work closely with that attorney to either get a portion of the workers' comp settlement that is owed to the parent who owes the support.
Teresa, I do have some questions on the liens and kind of using the tax refund method. Do you guys usually get the information on, how this payor has these other properties such as vehicle, boats and stuff from their social security? Or when the payor and payee are kind of applying for your services, they put down all the properties they kind of have? Like, how does this information kind of even come to your office that you're aware he has these types of things?
And when it comes to like liens on the personal property, that is information that usually is going to be the parent who owes the support will make us aware of. Oh, he just bought a new car, or I heard they just bought a house. And then what we can do is we would do the necessary research to see if it is something that they owe, and if it does meet the criteria for a lien. So like you may have an individual that says, oh, he just bought a new house, and we see that the house is homesteaded, then we can't place a lien on property that's homesteaded. But if they bought a vacation home and it doesn't have a homestead exemption, then in that particular scenario, we can place a lien. So just like with someone, we were talking about the licenses, because of the fact that our system doesn't have the ability to interface and get that information, that's going to be information that we're going to depend on either from the parent who is due the support, or, like the worker themselves may get that information and update the system accordingly.
Now, I have to look.
I was getting ready to say, that's okay. And when it comes to the tax refund offset, here's the thing with a tax refund. The person would have to file a tax return and do a refund. There are some individuals that don't file taxes. And if that person does not file taxes, then unfortunately, that case is not going to be eligible for a tax refund offset. But our system will interface, and we send the information to the what is it? Department of the Department of Treasury, the Treasury Department. We send that information over, and the case is certified for a tax refund offset.
Okay, so it's working with those other government partners that you have that becomes a kind of network where you guys get information from these other departments and they become aware of your support orders.
Correct. And then the last couple of enforcement remedies, bank accounts. The department does have the ability to levy an individual's bank account. Now that process it's not something that is going to happen in every case. When it comes to placing a freeze or seize on an individual's bank account, the Department of Revenue doesn't let me see, how can I say that? They're very careful as far as the bank levy process. So when it comes to a bank account, not every case is going to meet the criteria. They have strict criteria that they utilize. We only work with certain financial institutions, but there are situations where if that case meets the criteria for what we call a bank levy, then we will take the appropriate steps, and then there's a freeze placed on the account. And then, depending on the circumstances, we may have the ability to levy or seize the funds that's in that particular account. Okay, and then the last, credit reporting. We work with I always thought it was 3, but actually it's 4 credit reporting agencies. And if we have a situation where a person owes past due support, then that information can be reported to the 4 credit reporting agencies. And once it's reported, once it's on their credit report, it remains until their balance zeroes out. So if we have an individual that does not want child support to show up on their credit report, then they need to make sure that they do not fall behind on their child support. Otherwise, it will remain on their credit report until that balance zeroes out or equals 0.
So Teresa, when it comes to credit reporting, that's actually an option, meaning if they're paying, even it may be retroactive, but they're currently paying and they've always been paying little by little, then your office doesn't really put it then on these 4 credit reports.
Correct.
But if this is an individual that you guys just know is not paying, this is kind of a way to alert them of, you might want to work with our office.
Correct.
If you don't want this to show.
Correct. And with any of the enforcement remedies, credit report, bank levy, any of those enforcement remedies that I've touched on, there's always going to be a letter sent to the parent who owes the support saying this is what we intend to do. And those letters will tell them what their rights, what they can do to stop it. So anytime we're taking any of these enforcement actions, there's always going to be a notice sent to the parent saying this is what we intend to do and this is what you can do. You can come into the office office and do a payment agreement. You can pay their balance in full. So it's not like they're going to just wake up one day and we suspended a license and no one has ever told them. There's always going to be a notice sent, and credit reporting is no different. We're going to send them a letter saying this is what we intend to do, and this is what you can do if you don't want us to move forward with it. Okay, and then the last couple of services we're going to talk about is just the medical support and costs. Now, anytime the department is going through the steps to establish an order, and that could either be through the administrative or the judicial process, we're going to determine whether or not the parent who owes the support is going to be required to provide medical insurance. Now, it's not going to be always the case. It's there are circumstances they look at to determine whether or not the parent who owes the support is going to be ordered to provide the medical insurance. And if they are ordered to provide the health insurance, once that language is included in the order, then we're going to enforce it if that health insurance is available through their employer. If that individual is ordered to pay a portion or a percentage of the expenses that's not covered by health insurance, by the medical insurance, that's also something that we can enforce. So if the parent who is due the support has accrued like a $5,000 or $6,000 out of pocket for medical bills for the child or children, then they can contact us and we will provide them with the assistance to get reimbursed for whatever percentage the other parent is responsible to pay, if that makes sense. I think that came out. And then the last with costs, the only time the department seeks to collect costs is when we take an action using the judicial process. And the costs are always going to be something that we attempt to get from the parent who owes the support, the person who's paying the support, never from the parent who is receiving the support. But again, that's only going to be when we establish an order using the judicial process. Costs are not associated, or it's not something that we attempt to collect when we're establishing an order utilizing the administrative process. Okay, and then just the last thing, as far as some statistical information for the fiscal year 2020 to 2021, we have collected 1.6 billion, as in B, as in boy, $billion in child support. And out of that $1.6 billion, 97.6% actually went to the families. The remaining 2.4 was utilized to reimburse public assistance benefits for the child or children. And then as you'll see, the majority of that 1.01 billion, well, let's just say $1 billion was collected through income withholding, because like I stated earlier, income withholding is the most effective. And then the last thing, if you are interested in applying for services or you have a child support case, we offer what we call e-services. E-services is once you have a case, you can actually go in and create an account. And anytime you want to check the status of your case, you want to see if any payments came in, you can utilize e-services for that. If you wanted to get information on your case, you can contact us either email, phone, chat, or fax. And I think we have, one last slide with cost effectiveness, and then that's it. For every $1 that the Department of Revenue spends, we collect $6.42. So those are some good odds. And then the last thing is just that if you are interested in applying for services, or if you want some additional information, there's the website that you could utilize. That website will provide you with information as far as how to apply for services. If you're interested in e-services, that information is there as well. And Bertha, that's all that I have. If we don't have any, do we have any more questions?
Oh, we have questions, please. I do see from one of our other people here on that there is chats and there is emails. But for everybody here in the last slide, this is a CLE credit. This is the CLE number, and this PowerPoint and this slide is presented through the Facebook Live, but the title is Child Support Clinic, and it is approved from February 15th, to August 31 of next year. And now me and Teresa will be looking into the chat and discussing. So one of the questions is, what is the meaning of retroactive? So when you're talking about retroactive support, what does that mean?
Okay, so retroactive support is just this. It is the time period prior to the start of the child support obligation. So let's just say hypothetically, the child support obligation, that first child support payment is going to be due on March 1st of 2022. So we established a child support order, and that person is required to make that first child support payment on March 1st of 2022. But the determination is made that that person also had the obligation to pay back support prior to March. Here in the state of Florida, the statutes allow for us to address retroactive or collect retroactive support. I'm getting ready to cough, I'm sorry.
No.
To collect retroactive support 24 months prior. So now at the time, the 24 months prior is different. For a judicial case, that 24 months is 24 months prior to the date that the case was filed. For administrative cases, that 24 months is 24 months prior to the date that that person was served. So when we talk about retro support, let's say on a judicial case, the case was filed on February 15th. Well, the statutes say, okay, you can go back 24 months, will take us back to March of 2020. So that's retro. It's the time period prior to the start of that child support obligation. Once that child support obligation has started and that parent misses subsequent child support payments, that's just past due support. That's not retro support. So retro is just the amount that was owed prior to the start of the child support obligation.
Okay. And then that retroactive, do you guys then work with that payor to pay it slowly? Or does it all usually become like a lump sum? Like
no, typically with retro support, once that order is established, they're going to be ordered to pay a specific dollar amount towards the retro. So now we would never require a person to pay lump sum. Now, let me just add one little caveat to retro, because there are some things that could have an impact on the retro time period. So for instance, if during that 24 months, the parent was incarcerated 10 of those months, in that scenario, that parent is not going to be entitled to or eligible for 24 months of retro, only 14 months. If the parties ever lived together during the retro period. So if they live together in the middle of the retro period for 10 months, in that scenario, they're not going to be entitled to 24 months of retro, only the 14 months. So there are different things that can impact the total number of retro months that a household could be eligible for. So those are also things that we're going to consider when we're determining the retroactive support amount.
And another question somebody else had was, what is voluntary and involuntary change for modification? Okay. So what would you consider voluntary and involuntary?
Voluntary. I was working, I had a great job. I just got mad one day and quit. So now in that scenario, that's a voluntary thing. And that if that parent decides to come to our office and say, listen, I'm not working anymore, my child support needs to be reduced because I'm not making the money I used to make. Well, why are you not working? Because it was just, I quit. That's a voluntary thing. That may not necessarily warrant a review. And involuntary, a person is working and they're laid off, and they have been unable to obtain, maybe they have a job, but what they're making is nothing close to what they were making when that order was originally established, because there's just no work out there for them to earn that particular salary. In that scenario, that's an involuntary change. So involuntary is something that was outside of person's control, and then voluntary is a conscious choice or decision.
And the third question is, does the administrative process affect the birth certificate? And I'm guessing they're kind of almost saying is, does going administratively affect the birth certificate at all? Maybe the name of the father, not the name of the father.
So, and this is applied. This will apply in both the administrative and the judicial process. If paternity is an issue, if there is no father shown on that child's birth certificate, and we take the appropriate steps to establish paternity, once we have established who that legal father is, we will send information to the Bureau of Vital Statistics to have the father added to the child's birth certificate. Now, we cannot change that child's name. So if the child has one last name and they want the child to have the father's last name, through the administrative process, we can't do that. Now, through the judicial process, sometimes, and I'm not going to say it's all the time, but sometimes if they raise the issue at court, the courts may say, okay, we're going to go ahead and include in the order that the child's last name be changed to X, Y, and Z. And when that happens and we send that information up to the Bureau of Vital Statistics, they can change the child's name. But typically, once we establish paternity, our goal is to have the father, who is now the legal father, added to that child's birth certificate.
Okay. And the fourth question is, could you please clarify child support guidelines and the formula used?
Okay. So here's the thing with the guidelines. It's not a cut and dry. In the Florida statutes, and I want to say section 61.30 of the Florida statutes is where it addresses the Florida guidelines. And it is quite detailed and specific as to the income that we can use when we calculate guidelines, the deductions that we can consider when we calculate guidelines, the expenses that we can consider when we calculate guidelines. So I wish I could say that it's, a cut and dry formula. It's really not a cut and dry formula. It's pretty detailed, but the process entails getting income information from the mother, income information from the father, considering what the allowable deductions are, because just because a person has X amount of dollars for their 401k coming out of their paycheck does not mean that it's an allowable deduction. So we're going to look at the allowable deductions, and for instance, and this is not all of them, like federal withholding, FICA, if a person has mandatory union dues, if they're paying mandatory retirement, if they have health insurance, if they're paying child support for other cases, those are some examples of allowable deductions. And then with the formula, we get the net income. And then there's what we call a needs table. So the formula, it's not like just cut and dry. It is I don't want to say it's complex, but it's a detailed formula. So that's why, you could have situations where the circumstances could be the same. You have a mother, father, and you have two children, two different cases, but their income may be different. Their deductions may be different. So therefore their child support obligation is going to be different. And then we can also consider whether or not a parent is paying health insurance for the child and whether or not the parent is paying childcare for the child. So all of those things are things that we are required to consider when we're calculating guidelines. But again, the formula that we use is pulled directly from the Florida statutes.
And now just a question on allowable deductions. You may have a payer that comes to your office and says, well, I'm paying, mortgage, I'm paying, my credit cards back, I'm paying other stuff just to support myself. Does that count into your formula?
If you look at the statutes, the Florida, and this is not the great thing, but this is the thing with the Department of Revenue, is that we don't control it. If you were to go to the Florida statutes is clear as to what is considered to be allowable deduction. And when you think about mortgage, those are expenses. And those are expenses that really a person can control. The statutes state that the only expenses that we will consider when we're calculating guidelines are the expenses for the child. Childcare, health insurance. So mortgage, rent, all of that is not going to factor in when we are determining the child support amount. It is not an allowable deduction as far as the statutes are concerned.
And another question somebody has is, we understood that you said somebody who maybe is applying for public assistance and receiving those benefits, then you guys have that information and it's automatically given to you guys for somebody to then maybe want to go through child support. What benefits are we talking about here? Like, what public assistance usually flags your office to then start administratively the process?
So the way that the system is designed, when an individual applies for public assistance, when they submit their application, the Department of Children and Families, based on their income, their needs, and their assets, is going to determine what benefits they're eligible for. So when the Department of Children and Families makes that determination, if they see that they're potentially eligible for food stamps, cash assistance, Medicaid, or a combination of any of those, then that case is going to automatically interface with our system and it will create a child support case. Now, if the only benefit that they're receiving or they're eligible for is Medicaid, and that's it, they're not eligible for food stamps, they're not eligible for cash assistance, that's Medicaid. In that scenario, what happens is they're going to receive a letter to say, hey, If you want child support services, this is what you're going to do. So if the only benefit that they're receiving in that household is Medicaid, then it's not going to automatically create a child support case. They would have to actually follow the instructions on the notice to apply for services. But if they're receiving cash assistance, food stamps, Medicaid, or a combination of any of those three, it's going to be an automatic interface with our system, and then it will automatically create a child support case.
Oh, and another question is, you kind of spoke already on voluntary and involuntary, but let's say that you have a payor who was paying but now is incarcerated. Do you guys, or maybe that payor is incarcerated at the time that the mother or another individual is trying to go for child support, do you guys put income on there? Do you guys just put it as a period that he's just not allowed to pay, or that person will not be able to pay? How does it go by when somebody is incarcerated?
So it all depends on when the incarceration occurs. So let's just say hypothetically, we start the process to establish an order for support, and in the middle of the process, that parent is incarcerated. Paternity is not an issue, because if paternity is an issue, we can still attempt to establish paternity while that person is incarcerated. But if paternity is not an issue, or paternity has been established, at that point, we're not going to be able to address the issue of support, because we cannot establish a support obligation when a person is incarcerated, because that is what they call an involuntary thing. Even though we know that the crime may have been, who knows, voluntary or whatever, but in that situation, that person does not have the ability to obtain employment. Now, if it's a situation where the order has already been established, it was already established. So we have an enforceable order. We're enforcing that order, and now that parent is incarcerated. In that case, what happens is the parent who's incarcerated will receive a notice saying, if you want to have your child support reviewed for modification, this is what they have to do. But that order is still going to be charging, so they still have an obligation. And then once they are released, then they could, depending on the circumstances, file something with the courts to see if the courts will like wipe away whatever past support was owed while they were incarcerated.
Okay. And Teresa, we just want to say thank you so much for joining us. Your expertise and your time for being here has enlightened a lot of us, especially with the questions.
It was my pleasure.
So thank you all for joining us today for our first clinic of the year. And thank you so much, Teresa. Again, we really appreciate your time and your PowerPoint slides and just your knowledge. It's really been appreciated. Please be sure to follow and like us on all of our social media platforms, and check back for more clinics throughout the year. The link that Teresa provided for anybody who wants to apply online, that link, when you click on it, shows you so much on how to apply, the information you'll need. Most of the questions that were asked here are also on the website that Teresa provided as well. So go online to apply if you're looking for help with child support. And that link will be provided in the comments section as well. So thank you, everyone. Thank you so much. And thank you again, Teresa, for being here.
Thank you. It's my pleasure. Thanks for inviting me.